Fake news. Surely by now you know what fake news means. You've heard all about fake news from listening to politicians, from listening to legacy media, new media as they call it. You've heard that expression bandied about any number of times. What does it actually mean in family law? Much of it is fake news. Many lawyers will have a short, brief consultation with a client. Oh, we offer free consultation. Sure. The consultation that is free is typically a sales opportunity for a lawyer to sell a potential client on a product, which is a service. Totally fair, totally fine. We've all done it at one point in time in our career. However, fake news is what the client will tell the lawyer if there's only a 15-minute consultation. If a lawyer does not have an hour or more at a minimum to spend with a potential new client, how will you ever figure out all of their demons, all of the facts of their case to the extent possible in a short period of time? How will you know if your client is the more peaceful one, the more aggressive one, the villain in the situation, the serial cheater, a person that hides all of their assets, somebody that expects the lawyer to violate the rules and seek to hide assets? Well, you know their goals, their ultimate objectives, if you are not spending sufficient time with potential client. And as potential client, how will you know the true worth of your lawyer and the value of their services if you do not spend sufficient time with them interviewing them? That interview is mutual. A lawyer should be interviewing the client to make sure that there is an alignment of goals, an alignment of litigation style. I will litigate to the death if necessary, but that is not my initial posture. My initial posture is how do we obtain all of the facts necessary, organize that information in a reasonable manner, suggest likely court outcomes to a potential client and or your current client, and then develop settlement proposals before the case spirals into the typical litigation mode of temporary hearings, mediations, depositions, additional discovery, and the brinksmanship someday of a trial. How do we thwart that as lawyers to see if our clients can come up with reasonable settlements, stop the expensive trial, do not put your future financially and parentally in the hands of the robed judge? No offense, judges, but you say the same thing to me every time I go to trial. Are you sure you don't want to settle? You don't want your lawyer to litigate? You don't. Why don't you just go ahead and settle and so some stranger is not going to decide your life? And the judge says the exact same thing as I'm telling you right now. Do not wait for somebody who does not know you to make value judgments, moral judgments, financial judgments, parental judgments about and against or for your life. Instead, once you've obtained the facts, then you know what the case involves and what it does not involve. You know what the issues are and what they are not. That's a time for a reasonable settlement. But wouldn't you like to hear that strategy from your lawyer from the outset? Wouldn't it be nice if you could spend a full hour with your potential lawyer so that you know what to expect, the timeline of the case, how cases operate, how slow family law is, unfortunately, because most of the law is slow due to availability and due to the amount of time it takes to obtain documents, analyze those documents, schedule hearings, schedule mediations, mutually coordinate. This is not a fast process. We may live in an Amazon Prime society, but the law is not Amazon Prime. The law moves at its own speed, deliberate or otherwise. Slow as molasses, maybe, fast as lightning, maybe. I will leave it up to you to decide. Wouldn't it be nice? Let me reiterate this point. If you had sufficient time with your lawyer to understand his or her perspective, understand his or her litigation strategy, to understand their fee structure, to understand how much your case might cost, if you call a dentist's office or an accountant office and say, "Hey, how much the root canal?" Well, can we please see your x-rays first? Can we maybe have some imaging done? Can we evaluate whether or not you even need a root canal? And if you do, can we evaluate the extent to which you might have other damage around other teeth or gum damage, or whether or not there's anything necessary that has to be done and how extensive that procedure will be before we give you pricing? If you call an accountant and say, "Hi, I own a business. How much are my taxes going to be this year?" Well, do you need other services? Do you need to have payroll done? Do you need to have state and local taxes done? Do you need somebody to take all of your information, collect it, and identify what is a business expense, what is a personal expense, to identify what your actual budget is, what your strategy should be, give you tax strategies? Do you need all of these things? Are we going to be doing your personal returns as well? Would the accountant CPA be doing business taxes and personal taxes? Don't you think that they would want to know the number of hours they need to spend and the extent of your business? What if a major restaurant chain calls the accountant and asks that, and the accountant says, "Sure, I'll do it for $200 a month," and it turns out it's $5,000 a month? Would you really want that to occur on either side? Would you want to be beholden to do $5,000 worth of work for $200? That's not going to go anywhere. Or would you want to be in a position where you've understated what you have or you've overstated? Again, it goes both ways. Before you purchase something, you want to do research. Before you work with somebody, you want to establish that you have a rapport. The business of a 15-minute consultation, sure, I can help you with child support, $2,500. Okay, for what? What does that include? What are you going to do for me? And what information do I need to give you? What do you need from me? And that part of it is lost as well. Clients need to know what their expectations are, sure, as does the lawyer, and the lawyer needs to convey what their expectations are to the client. We need you to participate. And in my law firm, we don't hide things intentionally. We don't play little games with the rules. And if a client's strategy is, well, I have this double top secret business, nobody's supposed to know about it. I have this whole other family, shh, don't tell anybody. Then you might want to find a lawyer to the extent that they exist or do not. You might want to find a lawyer that's in alignment with your strategy, that takes a defensive posture. My goal in a family law case is to achieve the best outcome for my client, but to achieve the best outcome from our client by finding out all of the information we need to know. I mean, for instance, just one little quick for instance before we wrap up here. If the other side just had a child that's not yours and you do not tell us and you do not tell the court, then that child might be counted as yours, dude. That child born in a lawfully intact marriage, if you didn't tell your lawyer that the other side has a new baby that's not yours, you may end up paying child support for that child and being entitled to time-sharing rights for somebody else's child. You kind of want to tell your information to the lawyer. You want to tell everything to your lawyer. And that's when we can develop a strategy to help you. If we do not know, why would you want us to get blindsided? Who's to blame there? The lawyer for not figuring out something that you never talked about and had no reason to believe existed? Or the client who hid that information intentionally, seeking to omit that information from the legal proceeding? Think very carefully about that. Thanks, everyone. Have a happy holiday weekend.